Do we want both of them or just one of them?
Let's just do one of whoever's talking,
Okay,
because then it'll leave more
room.
PowerPoint room.
Okay,
We're ready to,
yeah.
all right. Well, welcome to state implementation plans and the Clean Air Act. And before I get started and introduce, how we're going to go through this panel, I want to acknowledge the Land, Air, Water members. There's one here in the corner. These are law students who, there's a former conference co-director there, Will Carlin in the green shirt. These are people who are putting on the conference. So students put on this conference and they sacrifice their grades, their time to do this work. And without that, this wouldn't happen. So let's give a round of applause to that. All right, so we're going to talk about how we get to clean, healthy air, which is the objective of the Clean Air Act. And the way we're going to present this panel is the timeline that is associated with that process of going from dirty air to clean, healthy, breathable air. It starts with the EPA developing a health-based ambient air quality standard. Then it transitions to the state coming up with the strategy. Then that strategy goes to EPA for review and approval. And then the plan is approved and time goes on to the ultimate deadline by which we must attain these standards. So our panel presenters are going to go in that order, from establishing the standard to developing the plan to EPA review and enforcement. So without any further delay, we have Maya Golden-Krasner, and she's going to introduce herself and kick us off.
Hi, everybody. Kind of weird that I can't see everyone, but hello. My name's Maya Golden-Krasner. I am Deputy Director of the Climate Law Institute at the Center for Biological Diversity. I'm also a senior attorney at the center, and I live in Los Angeles. So as Brent was saying, this panel's on state implementation plans, which are the plans that are needed to meet the Federal Clean Air Act standards, which are the National Ambient Air Quality Standards, or NAAQS. So I'm going to start off talking about NAAQS. Next slide. So I just want to give a brief overview about why do we care about the Clean Air Act. In most places across the country, the Clean Air Act has worked really well to reduce emissions of a criteria pollutants. So from between 1970 and 1999, for example, particulate matter pollution declined 75%, saving hundreds of thousands of lives. Between 1970 and 1990, airborne lead was virtually eliminated, with huge health effects greatly decreased. The benefits of the Clean Air Act range in the trillions of dollars, exceeding their costs by 42 times. And really the guts of the Clean Air Act are these NAAQS and SIPs. So the NAAQS are limits on concentrations of pollution in the ambient air set to protect public health and safety or to protect the environment. So NAAQS are for criteria pollutants that EPA has determined endanger public health or welfare and are emitted from numerous mobile or stationary sources. So it's really meant to be this economy-wide solution. The current criteria pollutants that are regulated under the NAAQS program are on your screen. EPA can add more pollutants if they meet these requirements. And once it adds the pollutants, it then sets the NAAQS. So there's the primary NAAQS that are set at a level sufficient to protect health, to protect public health with an adequate margin of safety. And the secondary NAAQS, which are set at a level to protect the environment, which includes climate. And EPA periodically strengthens or lowers the NAAQS and then sets dates by which the states have to reach or attain the NAAQS. Next slide. So focusing on criteria pollution is really critical to health, especially important in areas like where we work in LA, the Central Valley of California, and Denver. Ozone and particulate matter cause people to get sick, to miss work, kids to miss school, tax our health resources, and they kill people. And it disproportionately harms Black and Brown communities who disproportionately live near sources of pollution. Ozone and particulate matter also harm animals and plants, including many endangered species and the critical habitat that they need to survive. Reducing criteria pollutants is also critical to climate change. So, for example, ground level ozone or smog is created when volatile organic compounds and nitrogen oxides from combustion bake in sunlight. As the California Air Resources Board recognized in 2012, the only way to get to 350 parts per million and to meet the ozone and particulate matter standards is to decarbonize our transportation and energy systems. Next slide. So as I mentioned, EPA periodically lowers the standards if the previous standards were not protective enough. Or sometimes if an environmental group petitions them to do it and then they agree to do it. So one example is particulate matter. Trump's EPA kept a very outdated 2012 standards in place, despite tons of evidence that these were insufficient to protect public health. So in January of this year, EPA proposed new standards for PM 2.5, which is particulate matter with a very tiny diameter of 2.5 microns or less. EPA proposed only a tiny strengthening of the standard. So the 2012 standards that Trump kept in place are set at 12 micrograms per cubic meter and a daily level of 35. And EPA proposed to strengthen the annual standard to 9 or 10, but leave the daily standard and the secondary standards unchanged. Environmental justice communities, health experts, environmental groups, and others have been pushing for stronger standards. EPA's own science advisors asked for stronger standards that could save tens of thousands of lives. Comments are due by the end of March. Check out the Federal Register if you want to submit some comments. Next slide. So if a state or a region doesn't meet the standard, it's called being in non-attainment. So for example, Los Angeles is in serious non-attainment for particulate matter 2.5 and extreme non-attainment for ozone or smog. So we are in very bad non-attainment. So each state has to create a plan, the state implementation plan or the SIP, that details how the state intends to reach the standard by the deadline. If the state doesn't meet the standard by the deadline, they risk strong sanctions such as withdrawal of federal transportation funding, putting fees on the largest stationary source polluters, or EPA could step in and do a federal implementation plan. So what's in a SIP? A SIP is an emissions inventory, plus all the rules and regulations that will attain the standard by the deadline. So these are all the existing rules for new and existing sources, all the mobile source rules, all the state and local regulations. And these are supposed to be unambiguous, enforceable, measurable requirements. The SIP also has to have a demonstration that the state will or the region will make reasonable further progress to attaining the target by the deadline. Now, there are some, of course, loopholes or exemptions. So for example, for ozone, Congress recognized that it was going to be really hard to meet the ozone standard. So they gave them a longer attainment deadline and what's called a black box. So they could say, okay, we know we need to reduce X amount, but we can only get, 60% of the way there or a certain percentage of the way there, and we'll figure out how to get the rest of the way with new technologies and things like that down the line. And unfortunately for PM, case law has sort of allowed them to do a limited amount of the same thing, what are called enforceable commitments, which are pretty much, we're going to get most of the way there, and we really promise and commit to get the full way there when we figure out how. Next slide. And that our other presenters are going to talk more about SIPs. So I'm going back to NACs for a second. So one thing that the Center for Biological Diversity in particular has been pushing are what are called greenhouse gas NACs. So in 2007, in Massachusetts versus EPA, the US Supreme Court found that EPA has the authority to regulate greenhouse gases from mobile sources under the Act. EPA then went back and found that greenhouse gas emissions from mobile sources do in fact endanger public health and welfare, and their emissions cause or contribute to climate pollution. So there is precedent that, we know that you can regulate greenhouse gases under the Act. Obama tried to deal with power plant greenhouse gas pollution using the Clean Power Plan. And at the time, everybody said, yes, let's back the Clean Power Plan because it's way more likely to be upheld by the Supreme Court than a GHG NAAQS, which is crazy. So we're all going to back the Clean Power Plan. But it was not upheld by the Supreme Court last year. And in fact, in overturning EPA's use of, quote, outside the fence line measures in the Clean Power Plan, the majority contrasted EPA's application of that source by source provision under the Act to regulate emissions, which is section 111, which with setting a cap that must be based on some scientific objective criterion, such as the NAAQS. And that's a quote from the case. Justice Roberts noted that, quote, capping carbon dioxide emissions at a level that will force a nationwide transition away from the use of coal may be a sensible solution to the crisis of the day, end quote. But he wasn't saying just not under the Act's, quote, ancillary section 111D. In 2009, the Center for Biological Diversity and 350.org petitioned EPA to list greenhouse gases as criteria pollutants under the Act and set a GHG NAAQS. In July of last year, 7 state attorneys general wrote to EPA recommending the same thing. And as one Oregon Justice Department lawyer noted, the Inflation Reduction Act and the transportation-related reductions already underway still leave 48% of the emissions unregulated. And source-by-source regulation under Section 111D is too slow to address the climate emergency. So we think it's time to put the NAAQS to work to addressing the climate crisis. Next slide. So how would a greenhouse gas NAAQS even work? It's really complicated, but just very briefly, under the Paris Climate Agreement, the world committed to keep warming well below 2 degrees above pre-industrial levels, and is striving to keep it really below 1.5 degrees of warming. So EPA would have to basically determine the concentration of greenhouse gases in the atmosphere necessary to keep warming below the target level. So for example, they could set it at 350 parts per million. Then there's a bunch of new research on global carbon budgets, which is basically how much countries have left to emit before we blow past 1.5 degrees. So EPA could determine the reductions needed to ensure the US does not exceed its domestic carbon budget, and then apportion the reductions among the states, which would then create SIPs to achieve the attain the standard. So of course, one issue is timeline. So once EPA sets the target concentration, the entire US is going to be in non-attainment. And usually under the Clean Air Act, the attainment deadline is 10 years. It's obviously going to take longer than 10 years to reach 350 parts per million. But we think they could use the reasonably further progress requirements of SIPs to assure that they're attaining benchmarks every 10 years. And even if a court were to find that a statute does not permit a primary greenhouse gas NAAQS, it can still uphold a secondary NAAQS. So recall that EPA has to establish both primary NAAQS to protect health and secondary NAAQS requisite to protect public welfare. And this includes effects on wildlife, weather, visibility, and climate. A secondary standard does not require a specific attainment deadline. EPA can issue standards that will achieve attainment as expeditiously as practicable. Next slide. So finally, there are other ways to get at climate using the NAAQS. So one is reducing smog. So you'll recall that NOx comes from combustion, leads to smog. So reducing combustion to reduce NOx also helps with the climate. Another option is to get at methane, which is a very potent greenhouse gas. So actually, Robert Ukeiley, who's on this panel, and will be speaking later, filed a petition with EPA to include methane and ethane as volatile organic compounds regulated under the Clean Air Act as ozone precursors. So ozone or smog is created not only with NOx, but when volatile organic compounds react together with NOx and sunlight. So VOCs are considered ozone precursors and are regulated that way under the NAAQS program. So if a state wants to reduce smog, it has to reduce both NOx and VOCs. EPA has exempted methane and ethane from the regulatory definition of VOC since 1977. But research shows that methane and ethane, which are released in massive quantities, contribute appreciably to local and regional ozone levels. So areas located in the same airshed as oil and gas development, like Denver and Dallas, are increasingly experiencing high ozone levels that are at least partially due to methane and ethane emissions from upwind oil and gas operations. So these studies show that the need for EPA to revise the exemption of methane and ethane from regulation as VOCs. We petitioned them to do so, Robert. And so, so that's another way that we can get at climate. So now we're going to turn back to SIPs now that we know about NAAQS, and we'll talk about these plans to achieve the standards. And I'll throw it back to the rest of the panel.
Okay, thanks, Maya. Okay. Adrian?
Great. Well, maybe Candice and I will introduce ourselves and then we'll jump in. My name's Adrian Martinez, and I'm a deputy managing attorney in Los Angeles for Earthjustice. My preferred pronouns are he, him. And, you know, I've been working on Clean Air Act and state implementation plans for the last 2 decades in what I think a lot of people consider the nation's smog capital, although I think our friends from the San Joaquin Valley, you know, might say they are the smog capital, but we're both pretty bad, just generally. And I'm part of our Right to Zero campaign, which is looking to get to zero emissions in our transportation, our grid, our buildings, and now our industrial sectors. So Candice, do you want to introduce yourself and then we'll jump in?
Hi, everyone. My name is Candice Youngblood. My pronouns are she, her. I'm also an attorney with our Right to Zero program. I grew up in greater Los Angeles area. So I grew up exactly where we work with clients to address a lot of the freight transportation pollution that we have in the South Coast.
All right, let's go to the next slide. Oh wait, Candice, is it on the next slide? I can't see.
Yeah.
Oh, there we go. Okay. So what is a state implementation plan? Maya discussed it briefly, but it's basically a roadmap to meet national ambient air quality standards, or NAAQS, by relevant deadlines set in the Clean Air Act. And depending on how bad your area is, you get more time. So for example, in San Joaquin Valley and the Los Angeles region of California, for ozone, we get 20 years, which can be very long time horizons to meet these standards. Can we go to the next slide? So the other thing is, I'm having a hard time seeing my slide, but let me just, okay, hold on. Let me just pull it up so it's a little easier. But yeah, basically, you know, the structure of the Clean Air Act is to have a cooperative federalism type approach. And so, you know, the feds set the standards, and then states and in local jurisdictions develop plans to meet them. The EPA provides guidance. So a lot of times when EPA is setting a new standard, they'll do these things called implementation rules, which set kind of the parameters for meeting the standards. And then it's, once the states are in charge of developing it, they have a lot of discretion on what standards they choose and what strategies. Do they want to clean up locomotives? Do you want to clean up commercial ovens or space heaters? There's a lot of discretion. One of the things that I think Maya alluded to in California that's pretty interesting is when they looked in 2012 at how do we meet our greenhouse gas standards in California, our ozone standards in California, our fine particulate matter standards in California, the conclusions were actually surprising. I think most people would have thought that the greenhouse gas standards were the hardest standard to meet in California. And actually the evidence showed the complete opposite, that actually the driving force was ozone. Ozone is the hardest pollutant to tackle. And to do so, it led to this conclusion that Maya said, that we have to go away from incrementalism to a more zero emission approach. Can we go to the next slide? Oh, and then one last thing is, so EPA has to approve the SIPs. So it's not, they don't just go away forever. So the states have to meet these minimum standards, and then EPA approves them. And that's often where litigation comes in. You're often not suing the state of California or Texas or whomever. You're actually suing EPA over its approval of the plan. And generally what happens, they do notice in the Federal Register, and then you file your comment saying this is illegal because of X, Y, and Z, and then you kind of set your record like that. So yeah, one thing is just, I'm on my 5th big round of SIPs in the South Coast Air Basin or LA region. And so my one recommendation is, just don't sleep on SIPs. Bad joke up top that they're not that comfortable to sleep on. So, but seriously, these can be effective tools to address pollution and also protect communities. And I think to address the climate pollution problem that we're all concerned with as well. Can we go to the next slide? So one, just kind of to like how you would use a SIP, because we've spent quite a bit of time over the last couple rounds of SIPs in California to really get at zero emissions. And so this is, a quote from now deceased CEO of an electric bus manufacturer, just kind of stating what the science just generically said. We just need to stop lighting things on fire where people live. You need to stop burning fuel for moving our cars, trucks, buses, and whatnot. And so I think California is really showing that the SIPs or this kind of NOx-based strategy to reduce pollution can be an effective clean air strategy, but also address kind of the climate pollution. As I usually like to say in Los Angeles, our best climate pollution strategy is just to meet basic ambient air quality standards. Because if we do that, we're going to have to create such dramatic changes in how we move our economy that we're functionally shifting to zero emissions in the transportation and our buildings and our industrial sector. Now, let's talk a little bit about what this looks like. Can we go to the next slide? So this is from the 2016 plan in California. And one of the things that I think is important, there's a lot of news, and folks probably heard about some of the regulations that are coming out of California that are zero emission standards for vehicles. You might even be from a state that's going to opt in to some of these California standards. But I think the important thing to recognize is the kernel or the idea for these regulations, they all started in a SIP. And so in the 2016 plan, it was where we got that first kind of recognition that we needed to shift away from this incremental approach and go to zero emissions for our transportation sources. And so that plan, you really saw the first round of regulations proposed, and they were modest at first. So it was talking about vehicles that were kind of more prime for electrification, like airport shuttles, transit buses, but it also included, stuff for forklifts and trucks and other things. So that was kind of the start. And, we viewed it as a big victory at the time to get these handful of rules into the state plan. They were successful. The one thing I'll also kind of, and Maya kind of alluded to it before, is often the government develops these plans to make it hard to enforce, and there'll be some more discussion on that down the road. So, so you just have to kind of really monitor that, and sometimes it's hard. So during the administrative process on all these rules, in the plan, they'll set out, hey, we're going to adopt the rule by a certain date. And it will start to be implemented. Routinely those dates were missed. And so we kind of used the document to say, it's the first part of all of our letters to the California Resources Board. Hey, you promised to do this by this date. You failed to do it. You need to meet your promise. But I think it's really important on the front end to really comment and make it as enforceable as possible. And, a lot of the lawyers on this panel, like Brent and Robert and Maya, do a good job of kind of pushing back on the agencies. But okay, let's go to the next slide. And then one of the things, it's interesting. I mean, there's a lot of discussion these days around mandates. And one of our core strategies in the Right to Zero program is to get mandates. We view them as the most, the easiest way to get to zero emissions and to clean the air. And, that was kind of our prevailing notion. There are a lot of folks out there who talk more about, incentive-based approaches, using vehicle license fees to pay transit agencies or trucking companies to convert their vehicles, and those can be nice companion strategies, but mandates work. So in 2018, as a product of our SIP, we got the Innovative Clean Transit Rule, which is designed to get all of our transit buses to zero emissions by 2040 in California. And if you compare zero emission bus deployments across the country, California is leading, and I think it's because we have this mandate, this regulation requiring transit agencies to do it. You have a lot of goals and other kind of less mandatory approaches in other states, but I don't think they're as effective. One thing for folks out there that I don't think there's necessarily time to dig in deep, but transit is one area where you don't, where basically every state can do it on their own. Mainly because it's a procurement decision. So you don't really need to opt into California standards. For example, New York or Texas or Nebraska or whatever state can make a decision to shift their buses to all electric. Can we go to the next slide? The other kind of thing that's interesting that we did in the South Coast was, in the 1990 amendments to the Clean Air Act, they were exploring lots of changes, and encouraging places to look at market-based systems. We had a very terrible market-based program for stationary sources like refineries and power plants and those types of large polluters in the South Coast Air Basin. We actually used the SIP process in the South Coast after showing evidence that the program was completely broken. That was actually the policy document where they directed the staff to dismantle this broken program. So I think the other kind of thing you can do, and it's always hard, in different states are set up differently politically. You can also use this as a way to fix broken or misguided programs that might be in place to address pollution. And so, I encourage you to think about that. Can we go to the next slide? And then the only other thing is, transportation in California, but all over the United States is a huge issue. And I really encourage folks to use, the SIP process to kind of really get at transportation. The 1990 amendments theoretically were supposed to connect transportation planning to clean air planning. EPA, I think, has dropped the ball a lot in making those strong tools. And so there is some effort to kind of make these more meaningful tools. So we'll go to the next slide, and then I'll pass it to Candice to talk a little bit about addressing transportation.
Thanks, Adrian. Can folks see if I stand here? Great. So two of the ways that the Clean Air Act contemplates SIPs being able to address transportation pollution include transportation control measures and indirect source rules. So I'm going to start by explaining transportation control measures. So TCMs are a variety of strategies that reduce vehicle miles traveled and improve roadway operations to reduce air pollution, greenhouse gas emissions, and fuel use from transportation. Section 108F of the Clean Air Act outlines 16 different types of transportation control measures, and the EPA administrator has discretion to add more. But these are some examples of what those TCMs could look like. And what you may notice by looking at these is that a lot of them focus on passenger vehicles. They don't really get at the goods movement, which significantly impacts air pollution, especially since e-commerce has risen significantly in the last several decades, and especially since the COVID-19 pandemic. And so Section 108E of the Clean Air Act directs the EPA administrator to periodically and as necessary maintain a continuous transportation air quality planning process and to update guidelines and publish that guidance on transportation and other measures necessary in order to maintain attainment of the NAAQS. Section 108F, as I mentioned, outlines several examples of TCMs, so what it can look like. And it also directs EPA to work in consultation with DOT to publish and make available federal, state, and local environmental and transportation agencies information regarding transportation control measures and different ways that we can control transportation to attain the NAAQS. And that section also requires the EPA administrator to assess the effectiveness of those measures and to update that guidance periodically and as necessary. That guidance is important because states use that information to incorporate TCMs into their SIPs, and that guidance hasn't been updated since 1992, which you can imagine all of the different things that have happened in the last 30 years. Some of those developments include that the NAAQS themselves have been tightened. There's obviously been an unprecedented expansion of goods movement and related pollution impacts, which also means that there's been disproportionate negative health impacts on low-income communities and communities of color. They tend to live near sources of transportation pollution, including like along highways, near warehouses, the ports, et cetera. In the last 30 years, light, medium, and heavy duty zero emission vehicles have also become increasingly available and feasible and affordable. And President Biden has also, demonstrated a commitment to racial and environmental justice, which is outlined in several of his executive orders. And lastly, there have been billions of dollars that have been dedicated to transportation-related needs, in particular, the Bipartisan Infrastructure Law and the Inflation Reduction Act. So, this is an opportunity. Right now, we have an opportunity to sort of strengthen our TCMs because we have a favorable DOT secretary and EPA administrator. And so, if not now, then when would we request tightening TCMs? So the other way that the Clean Air Act contemplates SIPs addressing transportation related pollution is indirect source rules. So as Adrian and Maya mentioned, the Clean Air Act is structured on this cooperative federalism sort of structure. And so indirect sources of pollution are neither stationary sources, which the states are, delegated to regulate, or the mobile sources, which that's what the feds do, with exceptions for like California, et cetera. Indirect sources of pollution are defined in the Clean Air Act as a facility, building, structure, installation, real property, road, or highway, which attracts or may attract mobile sources of pollution. The Clean Air Act states that a SIP may include any direct source review program, so it leaves to the states the option to decide whether and how to regulate indirect sources. And so indirect sources can include warehouses, which warehouses have sort of spread in a very plague-like way throughout the Inland Empire and the South Coast Air Basin. And that has resulted in many communities being referred to as diesel death zones because of the disproportionate amount of transportation pollution those communities bear. And so Adrian and I work a lot in the South Coast Air Basin with community-based organizations to address some of the transportation pollution that comes from warehouses. And one specific example is that's specific to warehouses is the South Coast Air Basin's warehouse indirect source rule. So Earthjustice, along with our clients and allies, worked for about 6 years to advocate for the South Coast to develop a warehouse indirect source rule to sort of deal with this gap where, there wasn't a regulation to deal with the pollution that the warehouse industry was bringing to the Inland Empire. And so on May 7th, 2021, the South Coast finally promulgated their warehouse rule. And the rule's stated purpose is to reduce local and regional emissions of nitrogen oxides and particulate matter, and to facilitate local and regional emission reductions associated with warehouses in order to assist in meeting state and federal air quality standards for ozone and fine particulate matter. That rule applies to warehouses that are 100,000 square feet or larger. And the rule essentially creates this menu of options that warehouse operators can select to comply with the rule. And so there are about 32 different compliance options, and that includes that warehouse operators can elect to install or replace air filters in residence schools and hospitals. They can install solar panels. They can require fleets that service the warehouses to be electric. They can install different charging infrastructure, or they can pay a mitigation fee. They can also develop their own customized plan to sort of comply with the rule. This was a very big victory getting this rule passed, and essentially the freight industry freaked out. So in August of 2021, the California Trucking Association sued South Coast to challenge that rule. And shortly after, the airline industry intervened on behalf of plaintiffs. Earthjustice, representing two environmental justice organizations, and Sierra Club, alongside NRDC and EDF and another EJ org, intervened in the matter to defend the rule. And so the crux of plaintiff's argument is that the warehouse indirect source rule is actually about trucks. It's not an indirect source rule, and that, it's actually regulating mobile sources. And, they sort of proclaim that this is part of the South Coast's agenda to sort of force all trucks to be electric in the South Coast Air Basin. And they believed that the rule should be preempted. We don't think that. We think that it is a big win for, finally addressing the indirect sources of pollution in the Inland Empire. And so we have been defending the rule. This is being litigated in federal court, the Central District of California. And yeah, we're also waiting for EPA to have this rule approved and incorporated into the SIP, which will, we're waiting for that. And so, Adrian, could you talk a bit about this slide and sort of
well, I think Candice and I are going on a little bit. So let me just briefly say one thing as the initial results of how people are complying are starting to roll in for that rule. And I would say it's something to look at, because part of the issue is for getting to zero emission transportation, what we're finding more and more is it's not the vehicles that are the problem, it's the lack of infrastructure. And what we're seeing initially is that a lot of the warehouses are choosing compliance options to build charging infrastructure for their yard trucks and those types of things. So it's really worth looking as a potential strategy in other places. A lot of people are waiting to see what happens with the litigation, and we'll have a better sense on April 10th when we have our argument on the motion for summary judgment that the trucking industry and the airline industry filed. But I know that there's some efforts in New York and Illinois and other places popping up around indirect source rules. And I'd encourage folks to really look at it, because we're seeing really positive benefits from this rule, and we're trying to get more done in the South Coast on ports and rail yards. So it's a really effective tool to address the freight pollution. I guess that's it. So we'll pass it on to the next speaker. Thanks, everyone.
All right, so we're going to shift now into talking about enforcement of the SIPs, right? We've a little taller than Candice. So, right, we have the NACs being developed and the SIP being adopted by the state. Now let's shift over to why is my previous co-panelists have already talked about why we should care about these. Okay, air pollution kills people. Just the ammonia that is a precursor to fine particulate matter in California is estimated to kill 1,790 people per year. Just the ammonia contribution to fine PM 2.5. Okay, it's racially disparate. We know in California that for populations living near refineries, Black Californians are incurring a racially disparate impact. That means that they are suffering air pollution impacts that the comparative populations away from the refineries are not enduring. Now, that's an important term, so I want you to remember that for later, racially disparate impacts. We also know that from transportation pollution, when fuels are combusted, that those communities along roadways are also suffering racially disparate impacts in California. Nationally, EPA has recognized that PM 2.5 pollution exposure is disparate on the basis of race. That is, people of color experience exposure to PM 2.5 at rates much higher than white people. Again, as my co-panelists have described, this is, as we work on SIPs towards attaining these ozone and PM 2.5 standards, we're getting at co-pollutants, other pollutants that are released from the combustion of fuels or at stationary sources or refineries, greenhouse gases. So it's kind of like you're getting a twofer when you work on SIPs, even if EPA doesn't adopt a greenhouse gas NAAQS. So Maya was talking about the PM 2.5 standard that is underdeveloped now. Now this map is really important. So take a look. If EPA adopts the least stringent of the proposed measures, which is a 10 microgram per cubic meter standard, the shaded counties in this map are going to be designated non-attainment and will have to adopt plans to meet the standard. Up until now, California and some other areas have been ground zero for air pollution and SIPs and NAAQS and so on. But as you can see, even Lane County, here in Eugene, Lane County would be designated non-attainment for the annual PM 2.5 standard. When I look at this map, I see Philadelphia, I see Chicago, I see Detroit, I see Houston. I see all sorts of communities that are soon going to be in the situation that Adrian and Candice work on in the South Coast Air Basin. I have clients in the South Coast Air Basin. Oops, I forgot to introduce myself. I just got all into this, got all excited. So once I finish talking about this, I'll take a brief moment to introduce myself. You know, I work in the San Joaquin Valley, you know, this big green swath right here. It's already serious non-attainment for PM 2.5. So this is an important visual reminder of how important it is for more lawyers in other states to get involved in this process and get involved now. Because, you know, these impacts are racially disparate and the health impacts are tremendous. Okay, so back to me, introduce myself. I'm Brent Newell. I'm an environmental justice lawyer. I'm in private practice. Before entering private practice about a year ago, I was the legal director of the Center on Race, Poverty, and Environment for a number of years. I was also a public justice. I've been doing Clean Air Act policy and litigation for over 20 years now. One thing I learned in law school that has carried me through to today is a quote from a case that Mike Axline drilled into us as law students. He was the director of the Environmental Law Clinic here at the University of Oregon. Was this quote by Justice Brennan: ultimately, enforcement of the law is what really counts. So you can have laws on the books, but they don't mean jack if you are not able to enforce them and secure that relief for your clients. So there's three things I want to talk about today. First, the SIP is like a contract. Okay, law students can relate to this, even first-year law students. Second thing, enforcing the SIP. Third, we're going to talk about environmental justice and civil rights and the intersection of SIPs and Title VI. So, right, the SIP is a contract. So, for a contract, you have two parties who agree on something, right? And once that contract is formed, those parties can enforce the contract. The SIP is unique in that it allows citizens to enforce that contract between the EPA and the states. So citizens, in this instance, are third-party beneficiaries to a contract. You, any person, under the citizen supervision, can enforce the SIP in federal district court against polluters and against states to the extent permitted by the 11th Amendment of the Constitution. That just means you sue state officials and not the state themselves. So, you know, the Ex parte Young doctrine says you can sue the states through the citizen supervision to hold them accountable. The key thing here is that you can't enforce the NACs. So I can't represent a client and go to federal court and say, hey, the state of California is not meeting the ozone NACs. Give us an injunction. You can't do that. You also can't enforce the goal of a SIP to meet the NACs. Okay, so there's a little bit of limitation here. You can't enforce these other things that aren't in the contract, but that's contract law, okay? If it's in the contract, you can enforce it. So now we're going to talk a little shift. I'm shifting from my first thing to my second thing now. So enforceability is everything. You can enforce the strategies that are in the SIP. Now, the case citation there, Committee for Better Arvin, is a good example of what you can enforce and what you can't enforce. I argued this case and represented EJ groups in the Valley, the San Joaquin Valley, and we won on the issue of how California, all of its transportation controls that it chiefly relied on to attain the standard, they were not submitting these controls as part of the SIP. They were leaving those outside of the contract. Ninth Circuit Court agreed with us. They said, of course, these have to be in the SIP in order for citizens and EPA to enforce them. We then also tested a practice by the state to adopt what are called aggregate commitments. Just checking my time here. So what those are just like promises to achieve certain reductions. And we challenged them to make sure that we could enforce them later on. If we won in our challenge in this case, and the court said, right, these aren't strategies, they're goals, you can't enforce them, then we would have forced a revision. The court rejected our argument, saying, of course you can enforce these. So making sure that it's enforceable is critical. Now, these other, I'm not going to get into these other things a little bit here too much because I want to focus on what I'm going to talk about later. But it's important to understand that there's case law on what is in the SIP and what is not in the SIP. Or how do you interpret what is in the SIP? Okay. So those two cases are important cases to help you understand how to navigate around enforcing this contract. So let's shift over to the third thing. So Title VI of the Civil Rights Act of 1964 is a tremendous legal tool. It has been called the sleeping giant because of its reach and because of its absolute command. It says that no entity that receives federal money may discriminate on the basis of race. It's huge. There are limitations in how one is able to enforce this. And we're not talking about, this isn't a deep Title VI panel, so I'm not going to get into a lot of that stuff. But just believe me when I say that the mechanisms to enforce Title VI, you can't enforce a disparate impact in court. I talked about how there's all these disparate impacts from pollution, right? You can't go to court and enforce that under Title VI. You can file a civil rights complaint with EPA, but that agency then has to resolve that complaint. And there have been many, many problems over decades with getting agencies to enforce Title VI. This is one of my favorite pictures here, by the way, because you can see Dr. King looking over Lyndon Johnson's shoulder as he's signing Title VI, the Civil Rights Act. Now, what about Title VI in the Clean Air Act? Okay, so there's this little provision in the Clean Air Act that is being deployed now as a tool. So I can't get into too many details here because this is sort of a developing situation, as they say. But in a case I litigated and got a decision in 2015, the Ninth Circuit Court of Appeals recognized that this provision exists and that states have an obligation to provide necessary assurances that their plan complies with Title VI. Now think about that for a second. When a state adopts their plan to meet one of these standards in Detroit, or in Los Angeles or in the San Joaquin Valley, they have to show that their plan is not violating Title VI. Just back in October, what you see here, this is 87 Fed Reg 60494. This is an EPA proposed action on a plan from the San Joaquin Valley, where EPA reversed its proposed approval and it proposed disapproval of the plan for various Clean Air Act reasons. But also at the end, it says, oh, and by the way, you have to provide necessary assurances of compliance with Title VI. And we are not going to propose disapproval of the plan on that basis, but we expect when the state resubmits the plan that it provide those necessary assurances of compliance with Title VI. So right now, this plan, so let me back up for a second. Instead of allowing this process to proceed after the proposed disapproval, California withdrew its plan from EPA consideration. Rather than have EPA disapprove the plan and take final agency action on it, California withdrew the plan. It now has some deadlines to submit a new plan, and it has to provide necessary assurances, and it has to meet a bunch of other Clean Air Act requirements, some of which are pretty cool. So check out this proposed disapproval for more information on that. And now I'm going to turn it over to Robert, and we should have about 15 minutes at the end of the panel for Q&A. What's that?
Didn't it extend it?
Yeah, so we got 30 minutes left, and you've got about 15 to do your thing, and then we'll have 15 to do it.
Extended to 20.
Great. And we have another long Q&A.
Hi, thanks everybody for coming. My name is Robert Ukeiley, and I'm an attorney in the environmental health program at the Center for Biological Diversity. And I'm gonna kind of do the presentation you just heard backwards, meaning that I'm gonna talk about how what I've learned in enforcement actions or implementing actions have educated me about how the SIP could be better, and then work to change the SIP from what I've learned in implementing and enforcing. And I think at the end of the presentation, you'll be like, well, if he had just asked questions before he started shooting, he would have figured this out and saved himself a lot of time. But sometimes, you don't know how things are necessarily gonna turn out. So a little bit of background. So, we've talked about SIPs, and we've mainly been focusing on SIPs for areas that violate national ambient air quality standards. There are other types of SIPs. Like there's what's called the infrastructure SIP, and those apply statewide, and they kind of have the core components of a state's program. Many states had air pollution programs before the Clean Air Act existed. So things like that go into infrastructure SIPs. And then there are other SIPs that we won't go into, but like regional haze, like, when you go to the national park and you see smog, there are SIPs to like try and address that. So there are a variety of SIPs, and many of them, one of the components, and we've talked about how they have many different components or elements. One of the components is a permitting program, meaning that if you have an individual source of pollution, like a factory or power plant, or even like a university, you have to get a permit for that pollution. And the how that permitting system works, that's often included in the SIP. In terms of enforcement, oftentimes, you can enforce a requirement in the SIP directly. Like, let's say the SIP says all diesel generators have to put out less than 1 pound of pollution per hour. If that's in the SIP, you can enforce that directly. But in addition, if there's a diesel generator, it probably would have to get a permit. And you can also generally enforce that permit. And enforcement, I'm trying to move away from the term citizen suit, but that's what the statute refers to it. But the other terminology that's used is like private attorney general. And so a member of the public, including a nonprofit, can kind of deputize themselves to become the attorney general and do enforcement. You can't do criminal enforcement on yourself by yourself, but you can do civil enforcement. And so that's what I mean in this context by enforcement. So then I'll just go through a couple of examples of, where I've learned about weaknesses or faults in the SIP through working on enforcement action or through working on a permitting action, and then work to fix them. So that's I find that a really positive aspect of my work, is that if you don't like the rules, you can change them. And that's not always the case in our work, right? Like a lot of times you have to play the hand you're dealt. But with SIPs, you can change the rules if you think they're unfortunate. It's an extremely slow process, as you'll see from some of the examples. And it's difficult, and there's certainly not guaranteed success, but you can try to change the rules. So my first example arose from an enforcement action against coal-fired power plants. Well, it was coal and a frack gas power plant in Georgia, and it was owned by Georgia Power. So you'll see by the case number, it's Sierra Club, a nonprofit, versus the polluter. So we weren't suing the government. Again, it's just the Sierra Club basically deputizing themselves to be a private attorney general pursuant to what the statute provided. So we brought this enforcement action against this power plant that burned both coal and methane gas. And we won in the district court, and then on appeal in the 11th Circuit, the 11th Circuit said, no, there's this exception to their emission limits that say if they violate their emission limits during various stages of their operations, meaning when they're starting up the power plant, when they're shutting down the power plant, or when the power plant malfunctions, then they're not responsible for the violation. And Georgia Power's definition of malfunction was when the power plant did not act as intended. And they're like, well, we never intend to violate our emission limits. So therefore, every time we violate our emission limit, it's by definition a malfunction. So the 11th Circuit said, nope, SSM startup shutdown malfunction. They get out of jail, figurative, not literal, because again, we can't do criminal, but they get a get out of jail card. And we're like, but that makes no sense. People need to breathe all the time. And right, a kid's lungs doesn't care if the pollution comes during startup of a power plant or during like when it's at full board, like the impacts are the same. So it doesn't make sense. And the 11th Circuit says, we don't care, the SIP is the SIP. So the SIP becomes federal law until it's changed. And that's kind of interesting. Like we talked earlier in one of the earlier presentations about cooperative federalism. But so what that means as practical sense is a state regulation, once it's put in the SIP, is federal law. And yeah, the circuit courts, like what Adrian was saying about don't sleep on a SIP, you have 60 days from when notice of a final SIP is published in the Federal Register to challenge it. And if you miss that, that's it. Unless you like try and change it through a long petitioning process. But so you have that very short window. And then once it becomes the SIP, the fact that it's inconsistent with the Clean Air Act, you can't fix that in the context of an enforcement action. So that's what the 11th Circuit said. And they did kind of say, well, you can try and fix the SIP. And so that's what we did. We petitioned EPA to change the SIP to take that excuse provision, it's not a violation if it's during SSM, out of the Georgia SIP. But then we were like, well, as long as we're at it, we might as well do the rest of the country. So we also asked them, EPA, to fix these SSM provisions in 35 other states. And so we started that process in 2015, and we're finally getting across the finish line, meaning numerous states are fixing it. And that slowness is kind of, it would seem inherently bad, but, and I can't go into too much, but sometimes it's not a bad thing for the process to be going on. Sometimes it is. And so the other important lesson from this is it is a state-by-state battle. And I'm using state in the Clean Air Act sense. So oftentimes pollution is regulated by local authorities, like California has local air resource boards and other states do. And like each air resource board will have its own SIP. So like there's a separate SIP for the Bay Area in California versus the Los Angeles area. And so you do have to pay attention to like each SIP. It's each one is a separate thing. So another example is that in the permitting rules of Colorado's SIP, they have an exemption for temporary emissions. And the state has interpreted this to be fracking is a temporary activity. Because, and and they're actually like factually wrong, because sometimes you refract, so it's actually an intermittent activity rather than temporary. But they said, it only goes on for so long. And again, that just doesn't make any sense, right? Like if someone dies during that temporary emissions, like that's no comfort that eventually like in 3 months, there won't be that pollution. If you're dead, it doesn't help you that 3 months later, the air pollution will be better. So and you do get like multiple opportunities, especially for ozone, right? We've been talking about the level of non-attainment area. So there are 5 levels, and areas get bumped up over time. And each time they change their level, they get like downgraded from a marginal area to a moderate area. They do have to do a new SIP. And so that does present an opportunity to like fix the permitting program. So we submitted comments to EPA when they were reviewing one of these Colorado SIPs, saying the permitting program's defective because it exempts temporary emissions. And they said, thanks for your comment. This is the way we do it. And so we filed a lawsuit, and challenges to SIPs go directly to the Court of Appeals. I'm kind of interested in asking about why the trucking industry is in district court. But generally they go directly to the Court of Appeals. And so we have a case pending where we're trying to fix the permitting program by taking out that exemption. And then sometimes it's even worth it to go all the way back to the NAC setting to improve a SIP. So NACs have various components, like most things in the Clean Air Act. One is called the indicator, and that's the specific chemical that you monitor. So I'll wrap up quickly. But so for example, for one of the NACs is for nitrogen oxides, but the indicator, what they actually monitor and what kind of counts, what's enforceable, is just one species of nitrogen oxides, nitrogen dioxide. And so it leaves out in the permitting process and in the enforcement process this other species of nitrogen oxides called NO, nitrogen oxide. And so we're working now to actually change the NACs, because not only does EPA, not only can they create new NACs, like a new NACs for greenhouse gases, but they also review the existing NACs. And you can use that as an opportunity to make improvements. Because in the permitting process, we've learned that because they just look at nitrogen dioxide, it's much easier for sources of pollution to get permits, and and they're not as protective because they're ignoring this other pollutant. So we've gone back, not 2 steps back, to try and fix the problem. And then if EPA did change the NACs indicator to both nitrogen dioxide and nitrogen oxide, then the states would have to create new SIPs to implement that change in the NACs. And then once they change their SIPs, then the permitting actions would also change. So that's another example of where I've learned from participating in the end of the process, how I should go back to the beginning of the process to make changes. And I think we will open it up for questions. Sorry.
Around now, so.
We're gonna get Adrian and Maya up on the screen, I think. And we've got 10 minutes or so for questions before the panel's over. So any questions?
My question is for Candice, and Adrian about the warehouse index rule that was adopted by their quality management district recently. I was wondering about, so you're saying that you mentioned that there's recent data regarding, regarding the compliance options that are being adopted by new warehouse developers under their indirect source rule. You briefly mentioned that they're mostly doing, electrical infrastructure installations. Can you tell me about what options are being elected? Compliance options have shown like you aren't being elected by developers.
Yeah, it's a good question. Yeah, one of the interesting parts of the trucking industry's case against the South Coast over its rule is they're saying that the only option any rational economic actor would do is force the procurement of near zero natural gas trucks and zero emission trucks. So their theory is that there's some analysis during the administrative process that helped inform assessing the cost of the rule. I think what we're seeing in the data, and granted it's initial and it's not final, it's only preliminary, is people are choosing all sorts of stuff. They're using truck trips, they're buying trucks, they're installing, solar hasn't been one. And that kind of makes sense because that would probably be in a little bit of the later years, just how the rule's structured. But we saw a lot of charging, a lot of yard trucks, even some air filtration. Air filtration may be a result that it's often something we settle for when we challenge warehouse projects. So, but yeah, the cool thing is I think people are doing a wide range of strategies. And then the revenue, there's $5 million in fees generated now. That will probably go up to 15 to 20 per year down the road that can be used for cleanup.
Aaron.
Did you have a follow-up?
No, I didn't.
Okay, I have a follow-up on that. So I like the mandates too, Adrian. So if you had the political will in an air district, how do you feel about the menu? I mean, why not just mandate it all? Mandate, a sped up, accelerated electric truck schedule faster than the trucks rule. Mandate all solar. Mandate. Do you see a downside, or do you like the menu approach, or what do you think?
Yeah, it's a good question. I mean, and I think the menu approach was an inherent compromise. It wasn't what we were choosing first. They did it because, sorry, a little back clip, but they did it because there was the warehouse industry was claiming they needed flexibility, and that's why. And so I think. It's a little unclear. I think one of the problems with the menu-based approach is it's unclear how much emission reductions you're getting. So actually, when they recently, they're claiming to get about a 1 ton per day. And so I think if it were more prescriptive and mandate oriented, it'd be easier to calculate exactly how much emission reductions you're getting. So there's a port indirect source rule and a rail indirect source rule. They'll probably look very different. So I think we'll have more options coming out of South Coast that will be different. And so I think if folks are getting regulations in other parts of the country, there'll be more strategies or, information, different ways to do it.
Real quick, Aaron, the menu-based approach has been an issue that has been challenged in a petition for review of a SIP approval out of the San Joaquin Valley. And the Ninth Circuit affirmed an EPA approval and interpretation that was consistent with the required pollution control standard with which that provision had to comply. So it's been blessed by EPA as consistent with the Clean Air Act. Other questions? Was there?
My electric question that was mentioned, in the presentation
It's
about
a-
district.
Yeah, well, it's a two-part question. Who do they think the John Does are defendants? I noticed in the caption in the case, they named John Doe defendant. So I'm super curious who they think the John Does are.
That's a California law thing. I don't even know why, but it's routinely done.
I think we have two questions there was a hand here, we got a hand here and question over here. So let's go this way.
Well, I think my question was, why?
The question about district
Yeah,
court
why
is
is
that
district court?
EPA hasn't adopted it into the SIP yet.
Oh.
So we're waiting for them to do that.
I do have a separate question. too.
Okay.
For Brent, so with the section 110A, where the states need to provide assurance of compliance with other federal laws. Are there other laws that you've identified aside from Title VI that might be brought into that strategy?
The language of 110A2E is broad. And it says that they have to demonstrate, they have to provide necessary assurances that the SIP isn't prohibited by any provision of state or federal law. So, you know, under that language, it's quite open-ended.
Why don't you do that one before me?
Okay.
So it kind of goes along with that with the reasonable assurances, I think are like Part 70 permitting programs, part of the SIP. And then as it relates to what he was saying, where you have to challenge something within 60 days, are you able to use this reasonable assurances for old decisions under the SIP, or do you have to like wait till there's a new decision, or are there reviews of a SIP in which you can get that hook in? Does that make sense?
Yes, absolutely. So his question is about permits. Part 70 permit is an operating permit under the Clean Air Act, Title V operating permit. And he's also asked a question about this short period in which you have to decide if you're going to challenge an EPA action on a SIP. And the question was, is the necessary assurances provision, does that somehow get you around the short 60-day period, or does it reopen?
Right,
Think-
go back to old things, or are there reviews of the SIP?
I can't really answer that question right now because this necessary assurances thing is it's happening right now. But I will say that there's a provision in the Clean Air Act that authorizes the challenging of EPA actions where if new grounds arise after EPA action and after the 60-day period is elapsed, if new grounds arise, you can file a challenge. And I've done that in one of my cases before, is use.
That reopen it.
You just have to meet this standard new grounds arise in order to get back into the Court of Appeals to challenge an action. And we got in and it was a good outcome for our clients.
In a reasonable assurances case, is that on a new SIP?
I'm not going to talk about necessary assurances. Sorry, but I can't.
And Part 70 permit program is not in the SIP. It has a separate approval process.
Part 70 program.
A question there.
So
So
layman's question, all this good work you guys are doing with all of your experience and brain power and caring for the environment. We've got now a Supreme Court. How much of all this is gonna go up there and get shit canned?
They, it's extremely rare that they take SIP cases. The SIPs that they're interested in, like I was saying before, there's different types of SIPs. So there's one provision in the Clean Air Act that governs pollution from one state going into another state. The Supreme Court's kind of, and Justice Kavanaugh in particular, they have a bee in their bonnet over that thing. But the rest of it, it's way too factual. So
What about
they,
JP next?
yeah, that would end up in the Supreme.
and as Maya already said earlier, Justice Roberts and dicta
Yeah.
described, you know, a GHG NAX as something that he might like.
He's a.
But that's an
he's a
open question.
radical Liberal.
Yeah. Okay, we are at time. I'm gonna ask, is there one more question or are we gonna wrap it up? All right, thank you for coming, everybody.
Thanks, Candice. Well, bye.